So stop sharing it and come back in. Okay, now then what I'm going to do is I'm going to go over this removing the implied rights of access. I need to do this again. I've actually done a couple of videos about 3 years ago. I did one video and then I did a follow-up video to it. Now, obviously people share them all the time, and something that people have been sending me for the last few days is a video done by Daniel. So here's the video that I'm talking about. It's up on YouTube, and obviously that's Daniel, and that's me, little handsome one in there. Same barber probably, but I'm the more handsome one. This has been a few years ago, 2 years ago, maybe 2.5 years ago. My video was about 3 to 3.5 years ago. Been a mixed response on here. A lot of them not really sort of like agreeing with him. I'm not going to use all the swear words that are on there. Basically, I did a video on here, and some of the stuff that he said about it was kind of pedantic and misrepresenting the wording. And then there was a second part to it as well, which went over the differences between a high court enforcement officer or an officer of the court, whichever it would be, an agent or an officer, and a debt collection agent, what they call themselves, bailiffs sometimes, and they threaten people, I would say illegally, really. So there's a difference between them, you know. So let's stop sharing Daniel there, and we'll come back in and stick with my handsome features. Same barber, as I say, but probably I'm the more handsome one. Yes. What I'm going to do is I'll actually made some slides, and I've got a sheet that I'm going to read out to you as well, just to make sure that it goes over the case law and it shows you the case law of what we're talking about. Like I say, I'm going to go over the slides and it will describe it for you. But there is a big difference between a debt collector, right? And a lot of them that come from this company called Resolve Call, and they will just go and knock on your door with no authority whatsoever. They haven't got a court order. They've never even been to a court. They've got no writ. They've got no warrant of control. They've got nothing. Well, they'll have generally been sent by another debt collector who are trying to say that they've purchased the alleged legal title. The legal title can only be passed from one party to another with a deed of assignment. They never ever do that when they're talking about these. Well, they've said it in court, been in court many a times, and it says, well, all we have is spreadsheets, so we haven't got a deed of assignment. The judges accept that. Why? Because under CPR 27 on the small claims track, they're allowed to use their discretion. Another video coming soon about that. But anyway, these people that are knocking on the doors there, and they're coming, obviously it's very threatening, and they try to look intimidating, and they're demanding money with menaces. In some ways you could actually describe it, but either way, even if it's just knocking on the door and they're saying you owe money, I mean, they've got no right to be knocking on your door. You can remove their implied rights of access completely. They've got no contract with you. They've actually got no chosen action, is what it's called, for enforcing this alleged debt. They've got no court order, no warrant, nothing. So you can remove their implied rights of access. They've got no authority whatsoever. And that's completely different. Just say you got a high court enforcement against you for a debt or whatever it is there. Then the high court enforcement agents and officers are completely different. Let's call it a colloquial or a slang term, which is the bailiff. There's only one legal term, bailiff, like used in 2025 going onwards, and that's for like the county court enforcement agents, which they will call like bailiffs. But it's the only part, really, you know, that and we've used them a lot to go and get money from the debt collectors, and they never work, or at least they don't for us. Might do it for when they're working for the debt collectors, but they don't seem to be very successful when they're working on our behalf. But that's the only term. The rest of it is a slang term. So people in common parlance, people like, you know, the general public, when they're saying like a debt collector, they call it a bailiff, won't they? And that is where, you know, they try and be pedantic about what was said. I'm not going to start slagging anybody off or attacking. I'm not bothered about that, you know. And I'm only doing this because a lot of people have been sharing that particular video for whatever reason that they have. Nothing to do with Daniel. What I'll do is I'll actually share the slides, right? And we'll have a look at them, and I'll just go through it, and then I'll read out the sheet, and it'll explain what I'm talking about. What is removing the implied rights of access? Can you actually do that? Who can you do it to? And who can you not do it to? And what the difference is between the slang term, a bailiff, and what a high court enforcement officer is. The difference is, so you'll know what to do with which. Removal of implied rights of access. This is a public rebuttal. from moi. We're talking about, again, the misuse of the term bailiff. When I am talking about it, and I have been talking about it, I am talking about the actual debt collectors that have got no court authority, no court orders, no writs of control, no warrants, nothing like that. It's just what commonly known as a bailiff. People would say that term. You know it, I know it, so does everybody else. All right, they are private debt collectors for a private company. Now, this is before they've even went to try and get a CCJ, by the way. They try it all on, you know, and there is a difference, and you should never allow it to get to the stage. I've seen loads of people saying, oh, just ignore it, they'll go away, you know, you don't have to worry about it, or even get a CCJ and go, no, don't worry about it. Don't let it get to that stage. There's so many ways of fighting this without even having to go to court, by the way. You can use our advocacy program, but you don't let them get in to get a CCJ. But the private debt collectors, right, when they're coming and hassling you, and I've seen them, dozens and dozens of texts. You're getting texts 4 or 5 times a day. You're getting letters, you're getting emails, and then they come and knock on the door. We can legally revoke their implied rights of access. So if they knock on your door or they walk in through your garden gate, if you have one, now you can remove them and you can stop them being there. And I'm going to show you the case laws to support that. Case laws are there to show you exactly what is what. Who would benefit from confusing what I'm actually trying to say and trying to say, oh, no, that doesn't exist. You're making it up and blah, blah, blah. And, you know, a high court officer has got power. I'm not talking about a high court officer. That is obfuscation. That is muddying the waters. I'm talking about these private debt collectors that are trying it on. Who would benefit from that? Well, the corporations would definitely benefit from it, because people will then be even more stressed out, more worried, more intimidated. So who does that benefit? Doesn't benefit the people, doesn't benefit the ones that are actually allegedly, you know, being a debtor and trying to help with the families. Doesn't help them, does it? Helps the corporations. That's what I would think. Let's get down to it then. The term, the bailiff, right? The misuse of the terminology. It is just one of those words that we use, isn't it? In public conversation, you know, you're going to say, oh, the bailiff this, the bailiff's coming. Oh, have you seen the bailiffs? Don't let the bailiffs come. But really what we're talking about is a debt collector that's knocking at your door, talking about a private debt collector. If we're talking about like an actual court enforcement officer, legally, then we're only talking about the actual high court enforcement officers or high court enforcement agents, or, you know, like any enforcement agent that's sanctioned by the court. What we're not talking about is them. We're actually just talking about the normal public term of who's the bailiff. The only court employees that officially hold the title of the bailiff, I did say that before, you know, it is the title of bailiff. It's the county court bailiffs. But apart from that, we have high court enforcement officers or certified enforcement agents, and they actually have defined powers by whatever is written on their court order. So they can actually use things that, I mean, they can't force their way in, they can't break your door down and beat you up, which again, like a lot of people were saying, oh, so that means they can break in. Nobody was actually saying that, not me and not the other video, nothing. So we weren't saying that. But what you can do is when you're talking about the private debt collectors that haven't got a court order, not from a court, they're just from somebody who says they've alleged that they're an agent and they're acting for someone who says they've allegedly purchased your debt when they haven't actually anyway. They've just actually bought a spreadsheet of data on the internet. They are just debt collectors knocking on the door, trying it on. That's all they're doing. You can revoke their rights of access. You most certainly can. Now, all we're doing is we're trying to actually show you and clear up what is the difference. Why does that matter? Because the terminology mixes up the public understanding. And then when you're putting them all in together and saying that I was trying to say everyone was a bailiff and I was trying to actually talk about, like, you know, the high court enforcement officers, which I never was, then it's also going to like confuse the public even more. And if they do think that, I don't want them being intimidated or scared by these hideous debt collectors that are going banging on the door, you know, like without any authority whatsoever. That's why it matters. That's why it's important to go over this. What these doorstep debt collectors really are. They are not from the court. So we're saying that they're not a high court enforcement officer. They are literally a debt collector. They are going in there, banging on your door and interrupting your life And then they'll come up with all sorts of things. You must pay, you must do this, you must do that. They have got no authority whatsoever. They should not be on your property. They've got no right, they've got no legal standing to be on your property. So you can revoke their implied rights of access. And once you've done it, if they do not leave, then they are committing a trespass. This is what you should be looking at them. That's the type of tie, that's the type of hat, that's the type of face paint and hair. Not worrying about if they've got a suit on, a tie on, a silly wig on, or they're actually got a clipboard or whatever it is. Forget all that. They have got no legal powers whatsoever. They can't seize goods anywhere for a shop. If you're selling something, and if you've got your own house, you've only got private property anyway. They've got no authority to enter any property whatsoever. And they cannot force you to pay anything to them at all. If they haven't got a county court judgment or a warrant, all they're going to try and do is scare you, intimidate you. It's all bluff, it's all nonsense, and you've got to revoke their implied rights of access, tell them to leave, and if they do not leave, they are committing a trespass. So just bear that in mind. These guys knocking on the door that are just debt collectors that have got no warrants. They're coming from people like Resolve Call. Look, I've got my ID. I'm from Resolve Call. Yeah, you've got the same legal power as your pizza delivery driver, mate. So get your Domino's box and sod off in revoking their access. What the law says. We can remove their implied rights of access. There is case law, and we will show it, and I'll go over it on the paper as well. And it confirms that the public has an implied right to approach a house and knock. Now, however, that this license can be revoked at any time by you living there, being the occupier, whatever you want to call it. And you can do it by telling them, get off my property. I'm revoking any of the implied rights you think you have. Or you can do it in writing. You can have a sign, and all of it is valid. I'm not making it up. We do have support in case law. I'm going to give you the proper title soon, but you've got Davis versus Lyle. Go and check it out yourself. Robson versus Hallett, and Lambert versus Roberts. And the court ruled that if they stayed, whoever it was, be it a police officer, which some of them did involve police officers, if they stayed after being told that their rights have been revoked and they're not allowed to be there, they are a trespasser. They are continuing and committing a trespass. And these rules completely apply equally. If it can apply to a police officer, most definitely it applies to these numpty debt collectors that have got no CCJ, no court orders, no warrants, nothing. Now you can do it. If someone comes on, you can literally verbally say, I'm revoking your implied rights of access. You must leave now. And they have to. And if they don't, they are the ones that are in the wrong, and they are the ones that will get into trouble, not you. They always do this. They misrepresent and they abuse. Well, they haven't got power, but they pretend they have. Asking versus enforcing. What's the difference? Anyone can ask for money, but if you're presenting a demand as if it's backed by legal authority, pretending it because it does not exist, you haven't got a CCJ, you haven't got a court order, that is a form of misrepresentation. Listen, you must pay this back. This will lead to this. This is going to happen to you. We can take your goods. And I've heard it all before. You have, I bet you, and you've been there and seen it. And it is very, very common. All they're trying to do is they're trying to scare you. It's designed to intimidate and mislead. That's exactly what it is. They've got no lawful authority whatsoever. You don't need to talk to them. You don't need to do anything at all with your money to them. When we're talking about bailiffs, and it's a common word because it's a slang word and it still is around today, but in reality, if it's in a court, they'll be talking about a high court enforcement agent or high court enforcement officer. Terms like the bailiffs, are not used in these high court scenarios, but we all use it, and that is the thing. So it's got to be making sure that you don't actually mix it all up. These guys, right, that are coming, that I was talking about calling them bailiffs, right? They are just simple, plain debt collectors with no authority, and you can remove their rights, implied rights of access, and they've got no legal standing to demand money from you whatsoever. You have protection from people like that. You don't have to worry about people like that. If they are coming knocking on your door, you tell them to leave, you stand your ground. They've got absolutely no authority. They've got no county court judgments. They've got no warrants, no writs, no writs of control for your goods or anything like that. They are nothing. The confusion it is when they see other videos like that, who benefits from that confusion? Well, it's not you. It's not the public, it's not the ordinary people, vulnerable households, people with vulnerable in, got children in, the ones that are harmed or misused by this terminology, and it's misleading them and misleading the claims about their enforcement power. My clarity is going to help them and protect them. If these people are knocking on your door, sending you texts all the time, getting all of these emails and these letters all the time, they've got no authority. And never ever allow it to get to a CCJ. Get yourself defended well before that. And there's many ways to do it, and you don't always have to go to court to do it either. But rather than allowing them to get a CCJ, you can get this handled. Now, we obviously have our group, and I'm obviously talking about my group all the time, Checkmate the Matrix. You should get into the group, the private group, and then we can help you. And it's not just on this. I mean, we are not, by the way, a debt group. I mean, we've got information that we supply in there, educational content in there, from everything from crypto to private banking, obviously a little bit like on the debt, but also how to set up like an online business, how you can actually start creating your own wealth. There's many different aspects to it. It's not just about debt, but obviously when you're talking about the high court enforcement officers or agents, or compared to a bailiff, then that is what we're actually talking about. Forget the semantics. Don't worry about that. You have to know your rights, and obviously know that, yes, if you have got a high court enforcement officer that's got a court order, then make sure that you're dealing with it. You should have dealt with it well before it got there by getting into our group and learning. But if you're having them knocking on your door and have been texting you and everything, they've got no power. They've got no authority, and you can remove their implied rights of access. And if they do not move, they are trespassing. I'm not ever challenging the real enforcement powers of real enforcement agents. Got nothing to do with that, right? What we're doing is we're showing you the bluff that's used by the unregulated agents, right? The ones that are knocking on your door and going, oh, well, we've bought this debt, blah, blah, blah. It's got nothing to do with the real high court enforcement agents. Deal with it well before it gets there. But you deserve to know which is which, and you should know. And these ones that are knocking on your door coming from people like Resolve Call, they've got no power. They've got no authority. They haven't got a CCJ. They haven't got a court order. They haven't got a writ. They've got no warrant. They've got nothing. You know that. Then you've got the knowledge to make sure that you can protect yourself and do not get intimidated. Okay, so let's just going over the slides, letting you see a little bit more. What's the difference between high court enforcement? What was I talking about? I was talking about the debt collectors, right, that are coming knocking on the door, pretending that they've got like some kind of authority, and they've got none. So, and you know what they're like. I mean, they're texting you on the phone. They're sending you letters all the time. They put big red writing on. It's scary. And when they are doing these things and they're saying, and this is a different video series altogether, they don't even own the debt, by the way. And the ones knocking on the door are just the agents for the ones that pretended that they own the debt. So it's getting weaker and weaker and weaker. But I'm not talking about the high court enforcement agents or the ones that are from the court with authority. And please, if you've got in any debt situation or anything like that, deal with it before it gets to that level. Don't let them get a CCJ or a court order or a high court order, writ, whatever it would be. Don't let them get that far. There's ways of dealing with it, right, that'll help your peace of mind and your mental health and everything like that. So get it dealt with before. So I'm going to share like a notice that I wrote out so I can just go through. It's not like what you give to them. This is going to clarify the points that I'm actually making. So I'm going to share the screen, go over that, all right, and then you can make of it what you will. This information is provided strictly for educational purposes only. It does not constitute legal advice. If you are dealing with debt or legal proceedings, you must conduct your own research and, where appropriate, seek professional legal advice. This information is provided strictly for educational purposes only. It does not constitute legal advice. If you're dealing with debt or legal proceedings, you must conduct your own research and, where appropriate, seek professional legal advice. So the removal of implied rights of access. Let right be done. So when I say bailiff, I clearly and always refer to those unregulated door knockers from outfits that allege that you owe a debt that they've either bought or their mates bought. The ones who turn up at your door without a warrant, a court order, a judgment, or frankly a clue. They are not high court enforcement officers. They are not county court bailiffs. I explained that before. They are not certified enforcement agents under the Tribunals, Courts and Enforcement Act 2007. They are debt collectors, dressed up with intimidating language and hollow threats, but with no more legal power than your local Domino's delivery driver. Let's clear up the bailiff word once and for all. Yes, technically the word bailiff is still used, but only in narrow official sense. County court employees still carry the job title bailiff. That's it. That's the only legitimate use left in 2025. The correct modern term for most agencies, enforcement agent. High Court enforcement officers are not bailiffs. They are private officers authorised by the Lord Chancellor. So when people, as in the normal general public, say bailiff, it's a slang word. This simply means somebody at the door saying, I owe money. That's how the normal general public speak, and I'm referring to the normal general public. So if you're a barrister trolling through videos for clicks, this isn't a courtroom. This is a public market square, or where people down in the pub, and in the pub, words mean what people want them to mean, use them to mean, especially when the law backs it up. Here's what the door knockers really are. They are not agents of the court. They have no legal right of entry. They have no power to seize goods. They have no authority to remain on your land or in your home or anywhere once you say leave. They've got no power to enforce any alleged debt without first obtaining a county court judgment and a valid warrant or writ. They cannot lawfully enter property or seize goods unless acting under statutory authority as certified enforcement agents. And even then, they can't break in or anything, beat you up. That's nothing like that whatsoever. And from start to finish on court orders, it takes a long time, and you can act and stop that getting that far. Like I say, if you act fast enough. Want to know the difference between asking and enforcing? Simple. Anyone can ask for payment, but demanding payment with implied threat of enforcement without lawful power, that's misrepresentation. Can you revoke access? Can you stop these people that have got no authority at your gate? Absolutely you can. So let's go to the law. Davis versus Lyle, 1936, 2 King's Bench, 434. Police officers entered a garage, told to leave, they stayed. Court held, they became trespassers. Robson versus Hallett, 1967, Queen's Bench, 939. Lord Parker CJ, the householder gives implied license to any member of the public to come through the gate and knock on the door. That license may be revoked by the occupier at any time, either expressly or by implication. Lambert versus Roberts, 1981. Donaldson LJ, it is a license which is revocable without prior notice. The defendant's statement that the police officers were trespassing such as what was such a notice. If a police officer becomes a trespasser after a revocation, what makes debt collectors think they can hang about? So if a police officer can't stay, what makes these door knocking debt collectors think they can? Revocation can be verbal, it can be written, it can be a notice at the gate. It's all perfectly lawful. Some say this is all semantics, but when debt collectors start pretending that they've got rights and they haven't got any rights, and then barristers defend their language, what we must ask, who benefits from the confusion? Because it's not the public, it's not the struggling families trying to protect their homes, it's the corporations, it's the enforcement industry, it's the ones who profit from fear, ignorance, and silence. When someone criticizes you for saying bailiff instead of debt collector, they're not correcting your language, they're protecting a business model that's been built on misdirection. I don't refer to court officers. I never claimed HCOs or High Court enforcement officers lacked power. I clearly refer to private doorstep agents, the ones that have been sending you the text, the ones that have been sending the red letters, the ones that have been emailing all the time. And everything I said, it was about lack of authority. It's supported in law, as I've just mentioned above. Say otherwise is just either ignorance or spin or clickbait. Now, other people obviously sharing the videos. It wasn't even shared by Daniel anyway, but it keeps coming up and people making comments on it which are incorrect. So I need to correct that. All right, nothing to do with him. I'm not going to start attacking him. You know what I mean? Not really bothered. He does some good videos. He's trying to get up to 1 million viewers. So you can go and help him. Apart from that, I've got nothing to say about him at all. But what I'm saying is other people sharing it as if they're trying to stir the pot a little bit. But there is the fact. Now, when we're talking about there, I'm not going to go on and on and on because it's a different video altogether. I'm talking about the way that these debt collectors act when they allege that they've purchased your debt and they haven't. Right? There's a massive difference between purchasing block data on a spreadsheet between that and getting a legally executed instrument that will pass legal title from one party to another. In reality, if there is no legal title that has been legally passed from one party to the other, they cannot own that. Therefore, they have no legal title, which means they've got no authority to sue in their own name if they do not hold legal title. But that is for another video because that gets more complicated than just them simple things about a bailiff. compared to a high court enforcement officer. Watch out for that video coming soon, because I haven't done any for ages, just been so busy deep diving on AI, building AI. I was even away in America, like on courses, deep immersion learning on AI, and that's what we're going to start passing on to others in our group as well. We already have. So get into the group, Checkmate the Matrix. It's on school.com, and the classrooms in there are just filling up brilliantly, and you know, it's a brilliant platform. It's an incredibly well designed platform. So go and check it out. I'll put the link in the actual description, and hopefully see you soon. We'll have live meetings every week, and talking about topics like this, questions and answers, always learning all the time. None of it is legal advice, none of it's financial advice, none of it's like relationship advice. Everything you got to do your own research. We don't promise results, we don't guarantee nothing, the same as anybody else on there. It's even the ones that are like when you show people how to sort of like, you know, do online business. We can't guarantee results, and we never do. It's up to you to do your own research. It's up to you to do whatever's necessary to get your own results and the results that you require. Take care. We'll see you soon.